So, what are underground regulations? The Office of Administrative Law, OAL, in California is charged with ensuring that agency and department regulations are clear, necessary, legally valid, and available to the public. And OAL is responsible for reviewing proposed regulations by California's more than 200 state agencies and departments, boards, commissions, and other entities that have rulemaking authority. And the formal rulemaking process is set forth in California's Administrative Procedure Act, APA, and the APA sets forth the criteria by which OAL reviews regulations, as well as regular versus emergency rulemaking, as well as the ability to challenge so-called underground regulations. On the OAL website, which is www.oal.ca.gov, you can track on a table the list of rulemaking actions submitted to OAL for review by executive branch state agencies and departments. And this list is updated daily per the OAL. The website also contains a listing of underground regulation petitions that are under review by OAL as well. So if you have a potentially alleged underground regulation, the role of OAL is specified in Title I of the California Code of Regulations. Chapter 2 of Division 1 is actually titled Underground Regulations. So what are they? In CCR Section 250A, it provides the following definition of an underground regulation: to be any guideline, criterion, bulletin, manual, instruction, order, standard of general application, or other rule, including a rule governing a state agency procedure that is a regulation as defined in section 11342.600 of the government code, which is in the APA, but has not been adopted as a regulation and filed with the Secretary of State pursuant to the APA, and is not subject to an express statutory exemption from adoption pursuant to the APA. Now, in section 260 of the CCR, the submission of an underground regulation petition is set forth, and section 270 deals with OAL's review of these petitions. Section 280 describes the suspension of underground regulation actions. And basically, in terms of these alleged underground regulations, OAL is charged with reviewing whether any challenged regulatory agency action is in fact an underground regulation. So OAL explains that if a state agency issues, utilizes, enforces, or attempts to enforce a rule without following the APA when it's required to do so, then that rule is called an underground regulation. And as you might expect, state agencies, departments, boards, commissions, etc., are prohibited from enforcing any underground regulation. And if an individual or an entity believes that a state agency or department has issued an alleged underground regulation, then that can be challenged by filing a written petition with the Office of Administrative Law. Now, if OAL accepts that petition for review about a challenged underground regulation, then OAL may issue a determination. And OAL calls this program the Chapter 2 unit, or the CTU, because OAL's regulations regarding underground regulations are found again in Chapter 2 of Title I of the California Code of Regulations. And as I mentioned earlier, the OAL website provides information on underground regulations and how to submit a written petition to OAL, where they allege, or where you allege somebody challenging it, an underground or an action is an underground regulation. So OAL's review of an alleged underground regulation is limited to a three-step analysis to determine whether that alleged underground regulation must be adopted as a regulation pursuant to the procedures set forth in the APA found in our government code. First is the policy or procedure, either a rule or standard of general application, or is it a modification or supplement to such a rule or standard of general application? Second, has the policy or procedure been adopted by the agency to either implement, interpret, or make specific the law enforced, or administered by the agency or govern the agency's procedure? If the answer to these first two questions is yes, then the challenged rule is a regulation. However, before their determination is complete, OAL has to review the final step of its analysis, which is, has the policy or procedure been expressly exempted by statute from the requirement that it be adopted as a regulation pursuant to the APA? If the answer to this final question is yes, then the underground regulation naturally did not have to go through the formal rulemaking procedures set forth in the APA. However, if the answer to this final question is no, then the rule is an underground regulation and it cannot be enforced by the agency or department. Instead, it must go through the formal rulemaking procedure pursuant to the APA. Now, finally, you should be aware of Government Code Section 11340.5E, which provides that if an interested person has already begun litigation challenging an underground regulation, then a determination issued by OAL may not be considered by the court in that pending litigation. So those challenging an alleged underground regulation should determine whether they want to pursue the OAL review of the agency action or whether they want to go directly to court. How have the courts here in the state of California viewed underground regulations by the state's rulemaking bodies? In terms of a definition, the courts have ruled that any regulation not properly adopted under the APA is labeled an underground regulation, and an OAL determination that a particular administrative guideline is an underground regulation is not binding on the courts, but it is entitled to deference. There are several California Court of Appeal decisions in this regard, such as Davenport versus Superior Court and People versus Medina. Additionally, the courts in this state have noted that an underground regulation is a regulation that a court may determine to be invalid because it was not adopted in substantial compliance with the procedures of the APA. The courts of appeal have said this in Excelsior College versus Board of Registered Nursing, Patterson Flying Service versus Department of Pesticide Regulation, and others. There are some exceptions to the underground regulation rule. For example, agency advice or opinion letters are not characterized as underground regulations that violate the APA. So they are not properly to be considered when a court is considering the applicability, for example, of an IWC wage order. This was decided in a Court of Appeal decision titled United Parcel Service Wage and Hour Cases. In addition, protocols following mandatory guidelines are deemed regulations by the OAL, which may not be used by a state agency until they're formally adopted, following compliance with procedural requirements found in the APA. This was addressed in the appellate court decision in People versus Taylor. What is or is not an underground regulation? I hope you can hear is an important determination. If a state executive branch agency has engaged in underground rulemaking, then that action is invalid, and that agency or department, board, or commission has to complete the formal rulemaking process as outlined in the APA in order to ensure that that action is lawful and remains valid.